Okay. You all are safe at home and doing fine along with your near and dear ones during this unprecedented situation. I hope that we all shall come out of it very soon and get back to our normal routines. Well, I'm indeed very thankful to Gujarat Law Society and Madam Dr. Payal Mehta and her team for inviting me to conduct this webinar and talk about today's topic, that is relevance of human rights in pandemic situation, national and international responses. I have divided this talk in different parts. Firstly, I would talk about the pandemic and then understand what are human rights, and then would discuss some of the rights and their responses. The World Health Organization, WHO, on 11th of March 2020, declared outbreak of the viral disease COVID-19 a global pandemic. Due to the alarming levels of spread and severity, WHO called for the governments to take urgent and aggressive action to stop the spread of this virus. We know that COVID-19 is an infectious disease which is known to cause respiratory infections. There is no vaccine yet to prevent this virus, and there is no specific treatment for it other than managing the symptoms. While there have been noted instances of harmful and destructive diseases in the past, such as bubonic plague of 1903, the Spanish flu of 1918, and SARS virus of 2002, but none have had such a vast area of spread in such a short period of time. Lockdowns, curfews, quarantine, and travel bans have been imposed globally. Thus, the human rights guaranteed to people have been subjected to restrictions with these impositions. Now, what do we understand by human rights? Each individual is entitled to some rights which are inherent to human existence. Such rights should not be violated on the grounds of gender, race, caste, ethnicity, religion, etc. These are called human rights. Human rights are also known as basic rights, fundamental rights as mentioned in Constitution of India, natural rights or inherent rights. These rights are essential for all individuals as these are consonant with the freedom and dignity of an individual, and ultimately it contributes to social welfare. Protection of human rights is a necessity for the development and growth of an individual personality, which ultimately contributes in the development of the nation as a whole. The Universal Declaration of Human Rights contains civil, political, economic, social, and cultural rights. The UN Charter contains various provisions for the promotion of these human rights and fundamental freedoms in the preamble and in various articles. Apart from UN Charter, there are 4 international instruments created under the auspices of the United Nations known as International Bill of Human Rights, which include the Universal Declaration of Human Rights 1948, the International Covenant on Civil and Political Rights 1966, the International Covenant on Economic, Social and Cultural Rights 1966, and the optional protocol to the International Covenant on Civil and Political Rights. In India, the philosophy and objective of the Constitution of India is enshrined in the preamble, which include the protection of the dignity of an individual. For the fulfillment of the objective, Part 3 of the Constitution guarantees fundamental rights, or we call them as human rights, contained in the Universal Declaration of Human Rights to people, which is essential for the development of an individual personality. Part 3 of the Indian Constitution contains civil and political rights, and Part 4 contains economic, social, and cultural rights. Now, these rights include right to equality, the right to freedom, the right against exploitation, right to freedom of religion, cultural and educational rights, and the right to constitutional remedies. We are aware that at present there are more than 212 countries who have reported cases of COVID-19, and there are more than 35 lakh cases worldwide wherein the people are affected, and unfortunately more than 247,000 people have died, and the numbers are continuing to rise at an alarming rate. In the present situation, we all are aware that the governments are obligated to take effective steps for the prevention, treatment, and control of endemic, occupational, and other diseases. The enforcement of quarantine law and clamping of a nationwide lockdown has been done right from April 14 and shall continue till May 17th, 2020. India has adopted the common law remedies for quarantine enforcement, which have proved to be effective in the times of epidemics and pandemics. We have a code, that is Indian Penal Code, that deals with offences affecting the public health, safety, public nuisance, and the quarantine rule. These provisions are under sections 188, 268, 269, 270, 271, 290, and 291 of the IPC. Additionally, the Epidemic Diseases Act 1897, which was first enacted to tackle the outbreak of the bubonic plague in Mumbai in former British India, has been invoked by the government, and this has been frequently applied for the containment of epidemics like cholera, malaria, dengue fever, and swine flu. On March 11, the Cabinet Secretary of India enforced Section 2 of the Epidemic Diseases Act 1897 in all states and union territories in India to control COVID-19. And an ordinance amending the Act was also passed on 22nd of April 2020, enlarging the scope of powers of the central government and also penalizing an act of violence against a healthcare service personnel. It empowers the central and state governments to take special measures and prescribe regulations, and also provides for punishments like imprisonments, etc., similar to the Indian Penal Code. The Disaster Management Act 2005 has also been invoked by the government, and National Disaster Management Authority is established under this act, with Prime Minister being its ex officio chairman. This act obligates the central government to take all measures necessary and expedient for the purposes of disaster, which is COVID-19, including making proper and necessary allocation of funds, laying down guidelines to be followed by state, and most importantly, it obligates the central government to take all such measures as it deems fit, necessary, and expedient for the purpose of managing this pandemic. The Disaster Management Act has an overriding effect over any other law for the time being in force, and further grants immunity to the empowered officers from legal proceedings or actions deemed to have been carried out in good faith. Here I would like to refer to two cases. One is Gibbons versus Ogden, reported in 22 U.S. 9 v 1 1824, decided by the United States Supreme Court, wherein the powers of the state to enact quarantine laws and impose health regulations were held to be justified in cases of health emergencies, dangerous diseases, and viral infections. In India, in the case of Municipal Council Ratlam versus Vardichan, reported in AIR 1980, Supreme Court 1622, the Honorable Supreme Court of India, while deciding the case, gave an interpretation in the context of public health, safety, convenience, decency, and moral, linking sections 182 and 268 of IPC with section 133 of CRPC. It was held that decency and dignity are non-negotiable facets of human rights and are the first charge on local self-governing bodies. If we talk of the present situation, during ongoing pandemic, the most important right that we all are concerned with is right to health. Everyone has the right to the highest standard of health, physical as well as mental, under International Covenant on Economic and Social Rights 1966. It obligates governments to take steps to prevent threats to public health, to provide medical care to those who need it. Human rights law also recognizes some restrictions during serious public health threats and public emergencies threatening the life of the nation when they have. Now, when can we have the restrictions? When those restrictions have legal basis, are strictly necessary, based on scientific evidence, neither arbitrary nor discriminatory in application. They are there for limited duration, are respectful to human dignity, they are subject to review by the courts and proportionate to achieve the objective. Right to health provides that health facilities, goods and services should be available in sufficient quantity, accessible to everyone without discrimination, and affordable for all, even marginalized groups. The right to health is closely related to and dependent upon the realization of other human rights as contained in the International Bill of Rights, including the right to food, work, human dignity, life, privacy, access to information, freedoms of association, assembly, and movement. I would talk about some of these rights in the present context about which are very basic to all of us and which are affected due to lockdowns and quarantines. The first human right that is connected to the above right to health is freedom of expression. Under international human rights, governments have an obligation to protect the right to freedom of expression, including the right to seek, receive, and impart information of all kinds, regardless of frontiers. It is the duty of the government to provide education and access to information concerning the main health problem to all, including methods of preventing and controlling them. Government needs to ensure that accurate and up-to-date information about the virus, access to services, service disruptions, and other aspects of the response to the outbreak is readily available and accessible to all. Article 19(1)(a) of the Constitution of India states that all citizens shall have the right of freedom of speech and expression. The philosophy behind the article lies in the preamble of the Constitution, where a solemn resolve is made to secure to all its citizens liberty of thought and expression. The exercise of this right is, however, subject to reasonable restrictions which are imposed under Article 19(2) of the Constitution of India. The right is, however, not absolute, and it allows government to frame laws to impose reasonable restrictions, that is, in the present case, lockdowns, quarantines, etc., in the interest of sovereignty and integrity of India, security of the state, friendly relations with foreign states, public order, decency and morality, contempt of court, and defamation and incitement to an offense. I would refer to some cases decided by the Honorable Apex Court. The Honorable Supreme Court in the case of Ramesh Thapa versus State of Madras, AIR 1950, Supreme Court 124, held that freedom of speech and of the press laid at the foundation of all democratic organization, for without free political discussion, no public education, so essential for the proper functioning of the process of popular government is possible. Another landmark case of Maneka Gandhi versus Union of India, reported in AIR 1978 Supreme Court 597, it was held that freedom of speech and expression has no geographical limitation and it carries with it the right of a citizen to gather information and to exchange thought with others not only in India but abroad also. In Secretary, Ministry of Information and Broadcasting versus Cricket Association of Bengal, reported in AIR 1995 Supreme Court 1236, it was held by the Supreme Court that every citizen has a fundamental right to impart as well as receive information through the electronic media. Now, ancillary to this right to freedom of speech and expression is the right to access to information, which is provided under Article 19 of International Covenant of Civil and Political Rights. The access to information concerning the main health problems in the community, including methods of preventing and controlling them, is part of the core obligations of the governments and is an important aspect of right to health. Under the Indian Constitution, the freedom of speech and expression comprises not only the right to express, publish, propagate information and circulation, but also to receive information. Union of India versus Association for Democratic Reforms, another case reported in 2002, 5 Supreme Court cases 294, the Honorable Apex Court held that one-sided information, disinformation, misinformation, and non-information all equally create an uninformed citizenry, which makes democracy a farce. Freedom of speech and expression includes right to impart and receive information, which includes freedom to hold opinions. Now we talk about the responses of different countries regarding right to freedom and expression and access to information, which has been very different. If we talk of China, China withheld the basic information from the public, unreported. There were underreporting of cases of infection. They downplayed the severity of the infection and dismissed the likelihood of transmission between humans. There were reports of authorities detaining people for reporting on social media. In India and in some other countries, they have promptly made credible information widely available to public. There has been daily press briefings by health officials. Public service announcements to counter misinformation has helped to calm panic, restore public confidence. There has been encouraging people's assistance in the crisis. There has been publication of detailed data about the pandemic, and Arogya Setu app has been initiated, and there is banning or dissemination of information relating to COVID-19 on social media, which is unverified and false for the reason that scandalous and mischievous information can cause large-scale disturbances to public order. The another right which I would talk about is right to freedom of movement. Article 12.1 of the International Covenant on Civil and Political Rights protects the right to liberty of movement within the territory of a state. According to Article 12.3, this right can only be restricted in exceptional circumstances, including to protect public health or national emergencies. Restrictions such as mandatory quarantine or isolation of symptomatic people must at a minimum be carried out in accordance with law. Freedom of movement under international human rights law protects, in principle, the right of everyone to leave any country, to enter their own country of nationality, and the right of everyone lawfully in a country to move freely in the whole territory of the country. Restrictions on these rights can only be imposed when they are lawful for a legitimate purpose and when the restrictions are proportionate, including in considering their impact. Article 19(1)(d) and E of the Indian Constitution guarantees to every citizen of India right to move freely throughout the territory of India and to reside and settle in any part of the territory of India. This right is subject to reasonable restrictions imposed by law in the interest of general public or for the protection of interest of any scheduled tribes. Another right which is affected today very much is the right to practice any profession or to carry on any occupation, trade or business. As we see, the offices, the shops, the malls are shut because of the lockdown. This right is guaranteed under 19(1)(g) of the Constitution of India. However, a reading of Article 19(5) and 6 make it clear that reasonable restrictions can be imposed on these rights in the interest of general public, provided it is done by duly enacted law. In Narendra Kumar versus Union of India, reported in AIR 1960, Supreme Court 430, the Honorable Supreme Court held that to determine the reasonableness of restrictions, among other factors, it must consider the background of the circumstances in which the order is issued and whether the restraint caused by the law is more than necessary in the interest of general public. In another case, namely Banari Aman Sugar Limited versus CTD, reported in 2005, 1 SEC, page 625, the Honorable Supreme Court observed that a restriction does not become unreasonable merely because it operates in a harsh manner. We see that the lockdown is imposed in a very harsh manner with police taking control of the situation. In another case of State of Punjab versus MS Chawla, reported in 1997 to SEC 83, the Honorable Supreme Court has interpreted Article 21 in a broad manner, stating that right to health is an integral part of right to life. Now, responses of different countries in connection with the above rights is that in China, the government imposed an overly broad quarantine with little respect to these rights. In mid-January, authorities in China quarantined close to 60 million people in 2 days in an effort to limit transmission from the city of Wuhan in Hubei province, where the virus was first reported, even though by the time quarantine started, 5 million of Wuhan's 11 million residents had left the city. Many residents in cities under quarantine expressed difficulties obtaining medical care and other life necessities, and there has been chilling stories which have emerged of deaths and illness. In Italy, the government adopted progressively restrictive measures and imposed lockdown in phased manner. Now, another right which is affected in these times is the right to privacy. The right to privacy is enshrined in Article 17 of the International Covenant of Civil and Political Rights. It is also an important component of right to health. It has been recently recognized as a fundamental right under Article 21 of the Indian Constitution by the Honorable Supreme Court in the case of K.S. Puttaswamy versus Union of India, reported in 2017, 10 Supreme Court cases, page 1. Earlier on also, the Honorable Apex Court in the case of Govind versus State of MP, reported in AIR 1975, Supreme Court 1378, and in R. Rajgopal versus Union of India, reported in 1995, Supreme Court 264, The Honorable Supreme Court confirmed that the right to privacy is a fundamental right. It derived the right to privacy from both the right to life and personal liberty, as well as freedom of speech and movement. The right to privacy was said to encompass and protect the personal intimacies of the home, the family marriage, motherhood, procreation, and child rearing. However, the right of privacy is subject to compelling state interest. The right to privacy is not absolute. It owes its foundation in personal liberty and in that great human right of dignity, which resonates in all aspects of life. Privacy was acknowledged as a core component without which the free exercise of any fundamental rights would become redundant and hollow. However, the right, like all other rights, are subject to reasonable restriction. Now, response to right to privacy in India in particular has been negative, and to understand this right and the restrictions being imposed, we have to understand some situations like not everybody can be kept informed of a household being under quarantine. The milk vendor, the newspaper delivery boy, vegetable sellers, etc., all persons on the fringes of society and may be unaware of the developments in very many households which they frequent on a daily basis. It would be a catastrophe if these vendors are allowed to enter these homes or interact with those who are quarantined during the quarantine period. It is to safeguard the larger social interest that these liberties have been taken away and taken a back seat. Nevertheless, with the outbreak of the disease also, privacy concerns in the country are soaring. The lack of confidentiality of potentially infected persons has resulted in threats of ostracization of the family members by the community. States such as Karnataka, Delhi, and Maharashtra have resorted to applying an ink stamp on those who have been quarantined due to the worries that they may have contracted COVID-19. Some states have also published the details of those infected with the virus on the internet. Tamil Nadu has organized home quarantine stamps to be affixed on the doors of certain persons with travel history to countries or locations which have a high incidence of the disease. In India, the enforcement of fundamental rights themselves have not been suspended as in the case of an emergency. Therefore, the road not taken under Part 18 of the Constitution ensures that Fundamental Rights Chapter remains justiciable throughout the lockdown period. Keeping in mind the clear dictum of Honorable Supreme Court of India in Anita Kushwaha's case reported in 2016 8 SEC 509 with regard to the importance of right to access to justice, various courts including the Supreme Court of India has been working and hearing matters through e-conferencing in furtherance of circular dated 23rd of March 2020. The Honorable Supreme Court in recent case of Alok Srivastava versus Union of India, writ petition civil number 468 of 2020, while monitoring the state of migrant workers during the COVID pandemic, through an order dated 31st of March 2020, has passed some orders in favor of these migrant workers. Most of the high courts in India have been working, hearing urgent matters and passing orders throughout the lockdown period as guidelines for e-filing have been notified by the honorable courts. Of all the rights in great pantheon of civil liberties, perhaps the one most important is the right acknowledged by Article 21, the right to life. In conclusion, I would only like to say that a situation as thrown up by the present is a rarity and perhaps rightly so. The anxiety, the fear psychosis, and the legitimate worries of migrant workers and wage earners has never been seen before in 6 to 7 decades. What must be remembered, however, is that every human right and the rights enshrined in Part 3 and 4 of the Constitution are subordinate to right to life, which is the most vital of them all. It is this right that is challenged by the COVID-19 virus, and it is to protect this right that various measures have been taken by the governments of the world. While some vertical rights have indeed been curtailed, all horizontal rights in Part 3 of the Constitution are still in full flow, such as dignity, non-discrimination, prohibition, access to material and societal resources equally, etc., are all being followed, more so in these times than ever before. That is the trade-off we make as a society and as a nation to ensure all of us are alive when this great medical emergency passes. It is also a clarion call to remember the last few words of Baba Sahib Ambedkar in his last speech delivered in the Constituent Assembly on 25th of November 1949, the call for nationhood, the call for fraternity and a common brotherhood among all Indians during such times. For in Ambedkar's shining words, I quote, without fraternity, equality, liberty will be no deeper than coats of paint. Thank you all. Can we have some question and answers? If am I audible? Well, there has been question put by Mr. Kishan Brahmbhat. Uh, I think it's a mere speculation that the private hospitals would charge lakhs for COVID-19 treatment, and I guess the present government is doing the needful for checking these private hospitals where no exorbitant charges or other charges are taken for treatment of the COVID-19. So I think it is all a speculation by the uh, media that such a thing would happen. So let us hope this government is going to check the further availability of treatment to all the people who are affected with COVID-19. Yeah, if there are not many questions, I would like to put some additional points. First of all, as we see that rightly the emergency provision of Indian Constitution has not been invoked by the government. Otherwise, all the rights what we have, besides the rights which have been curtailed, would have gone to a toss, and the government has very appropriately invoked the Indian Penal Code and uh, the two laws, major laws, which are used for quarantine, that is the Epidemic Diseases Act 1897 and the Disaster Management Act 2005. There have been ongoing amendments and prohibitory orders and other orders which are passed under these acts, and the government is trying to control the situation while helping the people at large. I hope there is no further questions. Thank you very much. It has been a great opportunity for me to express my views live before all of you, and hopefully this webinars would continue in near future, and I would be given another opportunity to come in front of you and talk about any other topic which is relevant in the present times. Thank you very much. Kind of you. Jai Hind.